Please be seated. Hey, good afternoon, everyone, and welcome to the First District Court of Appeal. We have 4 cases on our docket today. We will take a approximately 10-minute break after the first case to have a coffee break with the lawyers. So we'll have that break between the first and second case. So we'll hear argument now in Blue One versus Gulf Power Company, 1D 20-2143. Counsel, you ready? Have you reserved any time?
Yes, I'd like to reserve 5 minutes for rebuttal.
Okay, thank you.
Good afternoon, may it please the court. My name is Mike Tomkowitz, and I'm here on behalf of Blue One LLC, the appellant and property owner in this matter. I have sitting with me Ms. Ashley Lucas, my partner. We're here today because the proceeding below, the trial court denied Blue One's request for non-monetary benefit attorney's fees because it relied on inadmissible evidence that the condemning authority would not use the easement as expressly written, and because it deemed Blue One's valuation hypothetical and somewhat speculative. This case is important for a few reasons. First, RFP Partnership, which is a case that we cite in our briefs, was decided in 2005. That court lamented that there was little case law explaining non-monetary benefit fees and what constituted a non-monetary benefit. Since 2005, not much has changed. My review of the case law, the First District Court of Appeals has not substantively analyzed this matter or issued any opinions. We cite many First DCA opinions in other parts of the brief, but with respect to establishing a non-monetary benefit, I can find none.
Well, let me ask you this. There's this easement, and Gulf Power wanted to use it for electrical lines, which are there, have always been there. But then this pipeline issue came up in the context of an offer for judgment under the statute, 73.032. Is that correct?
Correct.
Okay, so that statute says that when you make an offer of judgment, if you want to have a condition, you have to make available to the defendant the construction plans, if any, for the project on which the offer is based, correct?
Correct.
Okay, so the sole operation of that statute is to condition the scope of the offer, correct?
It is to promote settlement between the parties, but yes, the requirement to attach construction plans is designed to let the property owner know what the offer is based on. How can they consider an offer of judgment if they don't know the scope of the taking? If there are no plans attached to the offer of judgment, then the property owner has to look at the offer of judgment and consider it to be the worst possible scenario under the terms of whatever the taking is.
So let me ask you this. If the offer is accepted and the scope of plans is limited to only electrical lines, does that bind the offeror? Meaning, is that a legally enforceable restriction here on Gulf Power?
Correct.
To not ever use that easement for pipeline?
They can use it, but there's consequences now. So what they've done is they've bound them to those plans. If they say, look, here's $1.2 million, we're only going to use it as an electrical transmission line easement. We look at that and we say, okay, well, our claim was $6.5 million, but you're offering us 1.2 and you're saying you're not going to use it for above ground pipelines, which means that we can now cross that easement and reliably develop it. Great, we will take your offer, 1.2 million. If Gulf Power tomorrow or the next day, 10 years from now, 100 years from now, decides, you know what, we've got an easement, it says we can have above ground pipelines, we're going to go ahead and do that. They start building above ground pipelines in the easement area. Y River Farms instructs, which was confirmed by Trailer Ranch, that the property owner then gets to reopen the matter and assert additional damages, saying, look, you've breached what you said here. You gave me this deal. You framed the severance damages. I accepted an amount of money that was based on that, and now you're doing something different. So we're going to reopen the eminent domain matter, and now I'm going to assert the damages that are associated with your expansion of use. And so,
Well, isn't that when the attorney's fees would be incurred at that point? Versus
I think this is the stickiest issue of the whole thing, but it's important, and we've briefed it, but basically there's a monetary benefit fee based on measuring the first offer to the result. In this case, it was $88,000 to $1.28 million. If they do that and they give us an offer of judgment that restricts their use, our monetary benefit is measured still between that benefit. We no longer get a benefit in the follow-up case. So when they come in and they do above-ground pipelines, it becomes a supplemental procedure under 73092 that would be awarded hourly fees instead of a monetary benefit formula, because there would be no first offer in that scenario.
But is it your argument that the attorney's fees incurred in negotiations and litigation, all that leading up to the offer that was then accepted, that those, you're trying to recover those, that's what this is about, right?
Yes.
Okay, those have been incurred, and it basically boxed in Gulf Power to the point that they were willing to concede and just give up the pipeline? That's your argument?
Right, but the public policy behind why the non-monetary benefit fee should be paid, they no longer have to pay the severance. So they're off the hook for the majority of our severance damage claim because they've now bound themselves to electrical transmission line easements. But they're a condemning authority. And more than that, they're a private company that wields the power of condemnation, the power of the sovereign. And Canal Authority versus Miller and Trailer Ranch make clear that condemning authorities should only take the rights that they need.
Well, counsel, let me, on that point, I think you were counsel from the beginning of the case, including when the taking complaint was originally filed.
Yes, sir.
Right? And you didn't state any opposition to the scope of the taking order, right?
We had, the client, before engaging us, had tried to negotiate the terms of the easement, had tried to restrict it to the exact result that we ultimately achieved twice, not just once. That's undisputed in the record. By the time that it got to the taking, we basically told them, look, if they want it, they're gonna get it. That sometimes we can get some favor with them if we cooperate with them on the taking, as opposed to trying to fight them tooth and nail to change the terms of it. It's a very low bar, as you can review. Wye River Farms is the best case out there, because that basically says, look, if you're a condemning authority and you come in and you say, I have legal necessity to take these rights, you don't even have to have construction plans. You can just go in there and say, I have an engineering need, I'm gonna be able to do this, I'm gonna build above ground pipelines in it, and you don't have to have any plans in it. So that's a tough bar for the property owner to come in and say, look, they're not gonna use it for pipeline rights. That's so.
Well, but it doesn't seem appropriate to then complain that the public policy should be to limit a condemning authority to just what they need if you give up your defense, or if the statute doesn't even allow for you to make that kind of defense at the front end. I mean, I just don't understand. You come in the back end and say, well, they overtook, when at the front end you said nothing in opposition to the order of taking.
Well, and that's a great point, because I want to turn it around. Why didn't the condemning authority work with the property owner from the outset when the property owner approached him multiple times and asked for the narrow restriction to be added into the easement language? Whose obligation is it to work with the person? I believe that the condemning authority, wielding the power of the sovereign, has a higher obligation to cooperate and work with property owners who they're forcibly taking their property. They're not giving them a choice. They didn't want this. My clients were developers. They're using that big tract of land to create a mixed-use marina residential community. And I put pictures in the brief so you can see the site plans, and there's a bunch of testimony on that. But they went to them. They knew that the easement was expiring in 2012. And in 2008 and one other time, they went to them and said, look, I know that this easement's expiring. We're okay with you putting in the electrical transmission lines, but I want to make sure that I can access my property. I want to protect the investment-backed expectations that I had when I started doing this project. And so will you please work with me? And they emphatically said no. They basically said, we're taking a standard transmission line easement. We're going to need these rights, and that's what it's going to be. And so I'm not sure why the court would impose an obligation on the property owner to fight tooth and nail every step of the way. We tried. We asked them. They didn't want to do it. They wanted to take what they took, and they were recalcitrant in that. And it wasn't until we put in front of them a severance damage number of approximately $6.5 million that now all of a sudden Gulf Power, on the eve of trial, 2 months before trial, after 5 years of litigation, decided, you know what, let's make an offer of judgment and try to restrict the scope of this so that maybe we can get this thing done. Why is it our obligation to try to fight the taking to do that? Why is it not the condemning authority's obligation to try to work it out with the property owner any step of the way? I don't think there's any evidence in the record that the condemning authority reached out to us and we said, no, we won't talk to you.
Right, but it's the law firm that wants to get paid additional money for the non-monetary value being added. And so what is, aside from hiring experts or appraisers and that kind of stuff and putting the number in front of Gulf Power, what else did the
Yeah.
firm do to provide an additional benefit to the client?
And that's a great question, too. I've gotten this before. I've done a number of these. The question judges always want to ask is, how do we justify this large attorney's fee that we're going to now award you? And that's the difference in the benefit-based statute. In 1994, the legislature abandoned a quantum merit hours sort of analysis. And I was back here in 2019 arguing in front of Judge Makar about a non-monetary benefit award, and I was saying, look, that my benefit fee is going to be 1/6 of the fees that I incurred on this matter. We had incurred $600,000 in time. Condemning authority had incurred $900,000 in attorney's fee time, and my monetary benefit fee was $120,000. The court upheld the monetary benefit formula there. Sometimes it works out, sometimes it doesn't. But the legislature decided to divorce itself from this concept of how hard did you work to get it, and they said, we're going to look at what you achieved, the benefit and the value of the benefit to the client. And that's how this changed. And so sometimes it's great, and sometimes it's not. And it's tough to be an eminent domain practitioner because you have to navigate how that all works. If this turns out the way it's supposed to, it'll be a better result, and maybe it'll make up for the case in 2019 where we lost. So that's basically the strengths and weaknesses of the monetary benefit formula. So basically, to establish a non-monetary benefit, you have to look at two things. One, RFP partnership is my favorite case to look at an analysis and a framework for whether a non-monetary benefit's been achieved, despite the fact that the court found that there was no non-monetary benefit achieved in that matter. They basically found that whatever counsel had achieved, and they had achieved something, it was not a compensable eminent domain damage because it was a damage affecting the property at an interchange, not on the property itself. So
Who makes that call? The trial judge, correct?
Which call?
The call you just talked about, that standard.
Whether it's a compensable eminent domain damage?
Correct.
The law does, is what I would tell you. Do we satisfy the elements? Like, is there a legally cognizable claim? Our severance damage claim was legally cognizable. No one would argue with that if it's a change.
And I know you're familiar with the statute, probably well familiar with the statute, but I'm just reading the statute. To the extent such non-monetary benefits are specifically identified by the court, sounds like the court to me, and can within a reasonable degree of certainty be quantified, that sounds like the
Right.
court has to make this determination on
Has to
both
make-
prongs.
I'm sorry, I didn't mean to cut.
On both prongs.
Yeah, there are elements, so that I say three, but yes, identifying a benefit is certainly one of them, and that's why the court's order is so instructive on this point, because the court expressly finds that we helped our client. Quote from the order, "It is undisputed that by attaching the as-built plans to the offer of judgment, Gulf Power limited its use of the easement and thus framed the severance damages. The court further found that Gulf Power's offer of judgment contained the as-built construction plans resulting in avoidance of the worst-case scenario damages. Accordingly, the court found, quote, Blue One's attorneys undeniably helped their client," end quote. The court finds that there's a benefit in the express words of the order. She just goes on to say I'm not going to award it because of improper evidence. She looks at it and says the evidence shows that they're not going to use it the way that it says. I objected to that multiple times, got a continuing objection, gave her the law on it. The law is settled and very clear. You cannot rely on evidence that benevolent business practice, non-obligatory policies, all that stuff can't be the basis for finding that there's no damage.
Counsel, you have 2 minutes left in your overall argument. You can use it as you want, but you're running out of time.
Thank you, Your Honor. Basically, that's it. First, you have to find that there was a benefit achieved. Then it has to be by the attributes of counsel. The counsel has to achieve the benefit. And so there's RFT partnership and other cases look at this. When the benefit's included in a settlement agreement, it's legally enforceable as it was in the final judgment here. There's a bunch of cases on that. If it's a reduction in severance damages, DOT versus CNL Income Fund and DOT versus Winter Park Golf Club both show that when you reduce the severance damages, that's a benefit.
Counsel, if you weren't to win on appeal, Is your client on the hook for any of the fees?
No, that's not, the competitive market that eminent domain is, there's a lot of lawyers and there's not as many cases. And so in fee agreements, it's very typical, and I'm not sure I can identify any eminent domain attorney in my practice area that charges the client in the event that the court doesn't award the fees. The agreement is always, we will accept what the court awards. And so.
So the firm is actually the party in interest in this appeal? Is that
Correct.
right?
The firm is interested in the result, obviously. I don't work for free, so they would obviously like me to bring home attorney's fees to the extent that I can. But the primary error here committed by the court is that it looks at the easement, ignores the express words of it, and says, they're not going to use it this way. That's what the testimony shows. And that's prohibited by Smith versus City of Tallahassee, which is a First District Court of Appeals case, Houston, Texas Gas and Oil Company versus Hoffner, and Prebles versus Canal Authority, which is another First DCA case. So I would ask that your court reverse this order and remand it to the trial court for further proceedings consistent with.
Thank you, counsel. You've used up all your time, including rebuttal time, but I'll give you 1 minute for rebuttal after.
Oh, did I not reserve 5 minutes at the start?
You did, but you ran through it just now.
My apologies.
That's why I gave you a warning, so.
May it please the court, counsel, I'm Charlie Wiggins, and I appear here today on behalf of Gulf Power Company. Gulf Power requests that this court affirm the trial court's denial of Blue One's petition for non-monetary benefit attorney's fees. The trial court heard 2 days of testimony, both from the parties and from their respective experts. She weighed Blue One's evidence. She rendered a 8-page written ruling, findings of fact and conclusions of law. And in that written ruling, she found Blue One's evidence lacking. She was not persuaded that Blue One carried its burden of proof to establish that it was entitled, or that its attorneys were entitled, to non-monetary benefit attorney's fees. This court need not and should not second-guess the trial court's findings of fact in that regard. I submit to the court that the easiest way, perhaps, to analyze the rightfulness or wrongfulness of Judge Costello's rulings is to start with the statute. Both parties agree that the statute at issue is Section 73.0921B, which is found in the eminent domain chapter. That statute is permissive. It says a court may award non-monetary benefit attorney's fees. Unlike for attorney's fees based upon the value of the taking, non-monetary benefit attorney's fees are permissive. And to establish for a party to prove that it is entitled to non-monetary benefit attorney's fees, and that is a tongue twister, I apologize, they've got to jump through a couple hoops. There are a couple prima facie elements that they must prove to the satisfaction of the trial court. First, the party seeking non-monetary benefit attorney's fees has to demonstrate that those non-monetary benefits, whatever they are, were achieved through the efforts of the landowner's, the condemnee's attorney.
Well, let me ask you on that. The scope of the easement was pretty broad at the outset, correct? It included electrical power lines, and then also the pipeline came in at some point.
It includes a wide number of things that are, in the parlance of many of these easements, necessary and convenient to providing electrical
Right, but
energy.
the only existing utility was the electrical. Right?
That's correct, Your
Electrical lines, there's no pipelines.
Well, that's not exactly true, and I apologize. Let me withdraw that. There were certainly facilities for the transmission of electrical energy. There were also some telecommunications facilities that were coterminous on some of these aerial lines. to
Were
my
they cell
knowledge.
towers, or were they just cables, or?
I think they were just aerial lines that were strung on the towers on this easement. Yes, sir.
So Gulf Power, at some point, added in pipelines.
Yes, sir.
Okay. Now, let's just say that I'm the property owner, and I say, I don't want any pipelines, because I want to build homes and amenities, and I don't want these pipelines, and I don't have to be able to cross them, I need roadways. So I get lawyers, and I fight back, and I say, get rid of that pipeline easement. I'll get rid of that pipeline easement. And I spend a bunch of money on my lawyers. and then on the day before trial, you all do an offer of judgment getting rid of the pipeline. And this all, I mean, I'm trying to make it match here, but it's hypothetical. But haven't my lawyers achieved a non-monetary benefit in that case?
I don't necessarily agree with you, Your Honor, and here's why. When Gulf Power served its offer of judgment, it was very specific as to what it was, and I'm quite confident that this court has addressed the regular civil procedure offers of judgment under Chapter 7 to 68. The offer of judgment in the eminent domain statute is similar, but not identical. In the eminent domain statute, we broke down between the principal to be paid, the damages, so to speak, and the attorney's fees. And so if on the day that Blue One accepts that offer of judgment, whatever those terms might be, Blue One is entitled, or their attorneys are entitled to attorney's fees. In this case, $308,000. We didn't
For
dispute
how
that.
many years of litigation was that?
Well, opposing
sounds like
counsel
a lot.
characterizes it 5, but there was a companion case which sucked the air out of the room, so to speak, for several
All
years.
right.
And so if they're entitled to attorney's fees upon that, the acceptance of that offer of judgment, whatever that might be, the fees are already baked into the cake. They haven't done anything. They didn't put together an offer of judgment and send it to my desk for my signature.
But
That's
if they're-
something that Gulf Power did, and so therefore, if they're entitled to fees, the fees are the statutory mandatory fees, not the permissive.
Correct, but aren't they getting a non-monetary benefit that they sought at the outset, which was not to have pipelines across that easement?
I don't know if I would agree that there was a non-monetary benefit, but ultimately, if there was, hypothetically speaking, it wasn't due to the efforts of their attorneys. Whatever efforts of their attorneys were, whether they came to fruition and realized in a gain, monetary, meaning the $1.2 million or so, they're entitled to fees on those. We admit that, and we
Well,
paid those
why
fees.
did Gulf Power take pipelines off the table?
I don't know if they have been taken off the table, Your Honor. They are,
Again, I know, in the future, they could use their condemning authority once again and say, there's a judgment, we cannot put pipelines on here, but we'd like to condemn and to put pipelines in, right? You can come back and do that, your client can, correct?
yes, Your Honor.
Right, and at that point, we have a whole new set of litigation, valuations and all that. But at this point in time, isn't there a non-monetary benefit, or at least some benefit, that may be hard to quantify, that they've received by having that taken off the table? And I'm not sure why did they take it off the table? Was it purely altruistic?
I think I don't know if I would agree with the characterization that it was taken off the table. It is an undisputed fact, both from Blue One's, the testimony of Blue One's principal, and as found by the court, and as testified to by Gulf Power's corporate representative.
Well, there's no more negotiation about it. It's taken off the table in that sense.
I'm sorry?
There's no more negotiation back and forth. The litigation, you're litigating about the scope of the easement and the value of the taking. At that point, it's taken off the table in the sense that you're saying, we're not going to negotiate on that anymore, we're just not going to pursue it.
Again, I don't know if I would characterize it in that way because, and this is an undisputed fact before the court, the reason we ended up here today is because Gulf Power included with its offer of judgment the as-built plans. The as-built plans do not reflect an above-ground pipeline. Those as-built plans had nothing to do with Blue One's counsel.
But that's my question, going back. What prompted Gulf Power to put that into their offer of judgment? Was it altruistic? They just, we just don't want our community to have ugly pipelines, so we're going to take that out. I mean,
No.
what's the reasoning?
The reason why the as-built plans accompanied the offer of judgment is because, in Gulf Power's opinion, it was required under the offer of judgment statute.
Well, why isn't the answer that Gulf Power decided they didn't want to pay the $6 million for all of the easement? Instead, they just wanted to pay the $1 whatever million for easement minus the pipelines and just wanted to pay for what they already had and put into the future, if they decide to have pipelines, they can pay for it then. Why isn't that the answer to Judge Makar's question? In other words, why isn't the answer Gulf Power made a decision to segregate or sever the quantification of the taking to what you needed now versus what you may need in the future, and put off into the future what you may need until you decide that you need it?
I think your point is well made, Your Honor. In a perfect world, we could have a list of pros and cons on settlement, but on the eve of trial, when people are spending money, when there is a risk of loss, there are a wide variety of factors as to why a party offers a certain amount of money and at what time. And I
mean, do you dispute that Gulf Power ended up making an offer of judgment based on what it valued as the easement that it took to the extent that it needed it, and put off the table for another day the pipeline issue, which, of course, the $6 million presumed worst-case scenario, right, which would include pipelines, and you took that off the table with the offer, which would reduce the cost of the taking and cost for Gulf Power. I don't understand why you're not just saying that in answer to Judge Maker's
and the reason why is to attribute some magical significance to the amount of money that Gulf Power offered when Blue One's numbers were X, Gulf Power's numbers were significantly less than the offer of judgment. Trying to meet in the middle and playing armchair psychologist as what we think they might take, I suspect it was more a function of a dollar figure more than any non-monetary benefit or any sequelae of what was in the offer of judgment. It was a dollars and cents issue to get rid of the impending trial, which was going to be on the value of the taking.
But do you deny that the value of the use left for Blue One's property would be lower if you kept the entire easement, including the possibility of running pipelines above the ground where you're basically cutting off the property unless they build a bridge over it, I guess? I mean, do you dispute that the value of the property that they have would be less if you kept the possibility of pipelines being run on the ground over the easement?
I don't know that I necessarily do, and here's why, Your Honor.
Seems like you're afraid of conceding something, and I'm trying to figure out what it is that you're afraid of conceding.
The reason for my answer is this. When we talk about the specter of an above-ground pipeline, we cannot look at that issue without also taking a look at the property rights that existed from the very beginning of the lawsuit. In Gulf Power's petition or complaint filed in 2014, Gulf Power acknowledged and requested that the court afford Blue One a series of correlative rights, including the right to build roads over and across the easement, the right to install its own above-ground and below-ground utilities, including pipelines, and a host of other correlative rights. And so, ultimately, those correlative rights, meaning Gulf Power has rights pursuant to the taking, and Blue One certainly retains a lot of rights, were carried forth into the order of taking. They were ultimately carried forth and incorporated into the final judgment entered by Judge Costello. And so, if we say, okay, there's the specter of an above-ground pipeline, in light of those correlative rights, that specter becomes nothing more than a boogeyman, meaning it would be difficult, if not impossible, for Gulf Power to build an above-ground pipeline in light of the rights that Blue One retained during the entirety of the litigation. Ultimately, why did the trial court deny Blue One's request for non-monetary?
But then it sounds like the removal of the specter, even if it's a boogeyman, sounds like a non-monetary benefit. That's why I don't understand why you won't, you're unwilling to acknowledge that there is actually a monetary component to this whole thing, that Gulf Power decided, well, we're not going to build a pipeline anytime soon anyway, And if we just put in writing that we're not going to build a pipeline, we can drop that value from 6 million to 1 million because we're paying for just the value of the actual taking that we intend on using.
I think in Gulf Power's perspective, our valuation included a right, meaning the value that we thought we could put in front of the jury, included the right for us to build a pipeline, and we would just hash that out at trial. And so, to the court's point that we should have or could have made that an integral moving part of our offer of judgment is a point well taken. I don't know if it got that scientific, is my answer to that, Your Honor.
Well, if you look at the litigation expense, attorney's fees and costs, two parties are litigating over time. Was it 5+ years? And let's just assume that 90% of that was focused on the pipeline. Okay, so 90% of all the attorney's fees, costs, so forth, experts, all focused pre-trial and getting ready for this hearing. And then at the last minute, you take the pipeline, there's 90% of those fees and costs have been incurred, but that's not a part of the actual award they got. They only got their award here for the electrical line easement. So why shouldn't they get, I mean, it sounds to me like you, meaning Gulf Power, a utility, could have this broad scope of taking, litigate it, run up the costs for years, and then at the last minute, oh, we just want this little sliver. And we don't have to pay them that much, only $1 million and $330,000 in fees. Is that the way it's supposed to work?
Well, ultimately, if, by that logic, Your Honor, the non-monetary benefit attorney's fees didn't accrue until Gulf Power made its offer of judgment and they accepted it. If they thought, meaning if Blue One thought it was so unfair that they should only be compensated for the amount of effort they had put in to date, they shouldn't have accepted the offer of judgment. Let it ride, go to trial, and file whatever post-trial motions if they win or lose. Ultimately, however, I think this court should give dignity to the trial court's findings that, based upon the evidence in front of her, no non-monetary benefit was achieved by the efforts of Blue One's attorneys. In her words, I am not persuaded. I suspect it would be going a bit far afield if this court were to second guess that finding of fact by Judge Costello. I see that my time is up. I thank you for your attention here today. Thank you.
Thank you for your argument. Counsel, you've got 1 minute.
Apologies for not understanding the time clock. Just wanted to make 2 brief points. With respect to the subservient rights, the Court of Rights were all, we couldn't use them unless it was consistent with how they were using them. It's right up in the requirements. Provided that the exercise of such right of ingress and egress does not interfere with the safe and efficient construction, maintenance, and operation of the company's facilities and works. We couldn't just go ahead and access it. It wasn't equal footing. There wasn't rights reserved for us. We got the client what they wanted. This is all they wanted from the beginning. Ultimately, the use restriction is there. They have, in the record, said they would not accept the OJ unless that use restriction was there. Condemning authorities should narrowly take property. To allow them to kind of throw something out there, have an overly broad taking, and then come back and decide what rights they truly want at the end of the day is wrong, and this court needs to stop them. Thank you.
Okay, counsel, appreciate your arguments, both of you, and we will be in recess.